So I had a plan for how I would go through my talk, but there have been a lot of impromptu questions over the course of the afternoon, and I'm also just happy to take questions and bring up the slides as they're relevant to the questions. Is there a general sense for preference? No? Okay, I'll start with the talk and we can deviate as needed. I work in town. You guys can find me if you need to. So I was charged with talking about the legal implications regarding our end-of-life choices. And when I thought about that, I thought that it really brought up two issues. One is, how do we protect and articulate our end-of-life choices to ensure that they're honored? And then the other is, what are the legal consequences or implications to some of these choices? So I'm going to start with how we articulate our choices so that they're honored, and then get to the legal consequences of the different choices that we've talked about towards the end. Would you mind going back just 1 second? So we've already talked about some of this material, so I'm going to go kind of quickly, and let me know if you want me to slow down or if you have a question. There are 2 documents used to legally articulate your wishes in terms of end-of-life care. The legal documents are a power of attorney for healthcare decisions and a healthcare directive. It's also known as a living will. Sometimes those documents are consolidated into a single document. Sometimes they're broken out into 2. Some of you may have parents who did their estate planning a while ago, and occasionally you'll find a power of attorney that consolidates healthcare decisions and financial decisions into a single document. So it comes in different shapes and sizes, but those are the basic legal documents that are in play. And then, as was mentioned by a couple of the speakers, a post order is a medical document that conveys your end-of-life wishes. A post is a physician's order on life-sustaining treatment. In Washington, it's a bright neon green form. And someone asked a question about whether EMTs would honor that document when they come to your apartment or your house in the event of an emergency call. And the advice I generally give to people is that, yes, they will. They're charged with honoring that document. But in all of these situations, you need a vigorous advocate. So you need your loved ones to understand what your wishes are and to be there to vigorously advocate for you. Because these EMTs are charged with preserving life, and it's hard for them to let someone go. And yes, they will see the document, they're trained to look there, and they're charged with honoring it. But that doesn't mean that there's pressure to really confirm that, is this really what she wants, or is this really what he wants? So if you have open and clear conversations with your loved ones, and they can be your voice when you don't have one, that's really your best insurance. So the legal documents are kind of like I just described. Each state has some different requirements for how those documents need to be officially signed. So you need to make sure that your document complies with Washington state law if you're a Washington resident. And kind of just really briefly, for an advance directive in Washington, it needs to be witnessed by 2 people. They can't be your physician or caregivers, and they can't be people that are to inherit from you, so your children or beneficiaries of some sort. Some people will notarize advance directives. It's not a legal requirement that they be notarized, but it's not difficult to obtain a notary in a lot of situations, and a lot of folks believe that it just goes that extra additional step towards authenticating that this was, in fact, these are the wishes of the person who signed this document on such and such given day. So why not take that extra precaution if you have that available to you? Would you mind popping back just real quick? One thing that I think people don't quite understand, and this is true in different forms across all of the states, but in Washington, an advance directive just under the statute is very limited in nature. It applies in 2 situations. Either when you have a terminal condition, and but for life-sustaining treatment, you will pass away, or you're in a permanent unconscious state. There are a lot of points along our end-of-life journey that are well before a permanent unconscious state or a terminal condition, but for life-sustaining treatment to artificially prolong your death. And so in Washington, the statute allows you to supplement your advance directive so that it applies in those two situations, and then you supplement it to provide additional counsel for things that are important to you. A lot of attorneys are going to just present you with a basic statutory advance directive, just plucked right out of the statute. It's what they've been doing for years. I'm not being too critical, but you need to be really mindful that that document in and of itself is not going to get you to the place where kind of detailed end-of-life decisions are made and articulated. So what I suggest, and I think I mentioned this earlier in the presentation or in the day, is that we all complete a supplement to go along with your advance directive that really goes into detail about what it is you want and don't want. And I'll give you some examples of documents that do that. I think that's everything on that one. As was mentioned previously, in Washington we have a hierarchy of individuals who will make your decisions for you if you don't have a healthcare power of attorney or a healthcare agent identified. This is a good thing in a lot of situations, but it also can be a bad thing because the person who's identified on that hierarchy might not be the person who will advocate for you in the way that you want to be for the decisions that you want made. The other downside to our statute is that, well, it's a benefit and it's a downside, but is that consensus is required. And in a lot of families, that is very difficult to obtain. So if I have two parents, let's say, and something grave has happened to me, and we're discussing end-of-life options for me, and let's say I don't have the first four people on that list, and I don't have a document, then my two parents are going to be asked to decide my medical decisions, to be my voice. Well, let's say my parents are divorced and they can't decide anything together with any degree of productivity, but now they're supposed to decide my fate. That could be very difficult in terms of practicalities. It gets even more complicated, I think, when you have your adult children or your siblings making those decisions, because it's not at all uncommon to have a family where one or two individuals have vastly different views to the others. So I strongly encourage you to take action and fill out your own directive and appoint your own agent so that you have someone who's making the decisions you want made. Yeah.
So if we have this hierarchy, why is consensus required?
On a number of these appointments or levels, if you will, it's multiple individuals. So it's a class of individuals. So, yeah. Any other questions on that one? Okay. So my take-home mantra, and I think that of most everyone that was up here, is think really critically about who you're going to appoint as your surrogate decision maker. This person is your voice when you don't have one. Talk with them frequently. If you are the surrogate decision maker for someone that you love, then you are charged with applying the substitute judgment standard, which basically means you take your own values or your own wishes or thoughts about end of life and you put them on the table and they're not relevant. And what you're charged with doing is identifying what the person that you're advocating for, what decisions he or she would make if he or she were able to articulate his or her wishes based on the information that's available. So it's based on that person, it's not based on you. Now, that's kind of an academic distinction because it's really hard to put your belief system on the shelf and adopt this for another person. But it just goes to show how important it is for you to be really critical in your inquiry about who should be your surrogate. And kind of as I'm harping on this, when you appoint your surrogate on your power of attorney, please appoint alternates. So with any estate planning documents, I would encourage you to appoint your primary person, and then you appoint several alternates, because we don't know what life is going to be like and whenever this document is called up, and your first person might not be available. If you don't have that first person available and you haven't identified a second person available, then we could be in a situation where we have to initiate a guardianship proceeding to have a court-appointed individual, appointed for you, or we could revert back to that statutory hierarchy of folks. If you are not able to identify what the substitute judgment, what this other person would do in this situation, then you have to make a decision based on what you believe to be in his or her best interest. The reason I bring this up is that substitute judgment standard, if you complete your documents and if they have a great degree of detail in them, and if you go on and have detailed conversations with your loved ones, then whoever is your surrogate has this body of information to use to determine what kind of decision you would make if you were able to make it. If you just fill out an advance directive and then put it in the drawer and never talk about it, never think about it again, then when crisis hits and your surrogate is confronted with making very difficult decisions, he or she might not know what decisions you would make in the gray areas that come up in these conversations. So please provide them with the information that they need to advocate for you. Just a quick disclaimer. I was on the board with End of Life Washington, so I'm a little bit biased, but I think it's a fabulous nonprofit. And I think that they provide 2 documents that are of critical import for our state. And they've been mentioned briefly by some other speakers. The advance directive that they have is available on their website. So you just go, pull it up. It has several pages of instructions, very detailed instructions. And then it's a multiple page document that goes into a great deal of detail. I regularly direct people to that document if they're looking to do an advance directive on their own. The other document that's pretty cutting edge in the country is the Alzheimer's and Dementia Mental Health Advance Directive. So that document was originally formulated to apply for to folks who have some mental health disorders, maybe schizophrenia or bipolar disorder, so that they can articulate their wishes for future events when they may not be thinking as they would now. But it was I'm sorry, I misspoke. Our mental health advance directive statute was created with those types of mental health diseases in mind or issues in mind. The Alzheimer's and Dementia Mental Health Advance Directive is specifically geared towards the issues that you will face if you or a loved one is confronted with an Alzheimer's diagnosis. And so it goes through, it's a very detailed document. The key pieces that I would have you recognize, and I think they're common sense based recommendations, but if you or a loved one is confronted with some type of cognitive diagnosis, then you have to plan early. And I don't remember who it was, but they said that all of us should have an advanced care directive, and I believe that that's absolutely true. But that directive should change over time as your medical reality changes. And if you are suspecting cognitive decline or if you've received an early diagnosis, then your best gift to yourself or to your loved one, whoever it is to plan and to plan early. Because once that disease has progressed, you've lost the ability to do so. And then you really are dependent upon others to advocate for you. So both of these documents are great resources. I encourage you to pull them up, look through them, fill them out. You can call End of Life Washington if you have any questions. They're fabulous documents. I was also asked to talk about capacity. And I think that Lisa did a good job talking about the issues that come up with regards to capacity in the context of a Alzheimer's or dementia diagnosis. I guess as an attorney, I have some, nerdy comments about capacity. There's 2 types of capacity that are relevant in this conversation. Legal capacity, which is required to execute a legal document, And then decision-making capacity, which is required to be able to provide informed consent to a given medical procedure or decision. So for legal capacity, you need it at the time that you sign a document. Some attorneys will have a very rigid litmus test for legal capacity, meaning that if you present with any type of cognitive impairment diagnosis, they will just assume that you don't have capacity. Others will actually engage you in conversation and parse it out and see if you do have the decisional capacity to understand what it is you're signing and who it is you're granting authority to. So that will vary a lot from practitioner to practitioner, but it's defined right up there. You don't have to know the particulars of all the medical or legal jargon that's contained in the document. You don't need to know all of the specific details about maybe the trajectory of your illness, but you need to be able to understand, to meaningfully understand what it is you're signing and who it is you're granting authority to. Decision-making capacity is a medical determination, and it's the ability to understand the basic information necessary for informed consent and understanding the nature and consequences of authorizing treatment. I've taken this portion of a slide from a previous presentation I heard from a physician, because this is obviously out of my wheelhouse. I don't determine medical capacity as an attorney. But some of the key inquiries that were identified is, can this patient express a stable choice? Can this patient understand the relevant information? Can they appreciate that information? And can they use reason and logic in making the choice? And it's important to recognize that capacity is not an all or nothing thing. And that would apply, I believe, as well in the legal capacity realm. You might have really good days. You might wake up, you might have a dementia diagnosis, but you know that you're more clear in the morning. You might be able to track conversation more clearly in the mornings, but then by the afternoon you're fatigued, and it's a lot less likely that you'll be able to track and follow conversations or understand the import of something you might be signing or granting. So I think it's just something that we need to be aware of when we're talking about capacity. I've talked about this a lot already. I think the one piece that's not on there that I would encourage you to consider is that it's sometimes really difficult to have these ongoing conversations with your loved ones. Maybe if you're here, this is a self-selected group that's already comfortable talking about death and doesn't have the normal inhibitions that a lot of folks have about this. There's a document on the End of Life Washington website. If you go to the upper right tab on the website, there's a document library tab, and under that there's a document that it talks about, I think it's called like the medical IQ test or something like that. And basically it goes through, it presents you with 5 medical scenarios or 5 fact patterns that you can talk through with your surrogate decision maker. And these are not simple, easy ones, like would you want the proverbial plug to be pulled if you were a quadriplegic and you had, completely diminished cognitive function? Most people would say, yes, please let me go, don't, submit me to a bunch of interventions. But these decisions are very nuanced, and so this IQ test that you can find on the End of Life Washington website really guides a very profound conversation between you and your surrogate decision maker to really understand what are the gray areas for where you would want intervention and where you wouldn't. So I encourage you to look up that document to help with those conversations. Okay, so now we're going to talk about the legal consequences of the decisions that we've talked about. In Washington, we're fortunate that death with dignity is, at this point in time, a fairly well-established right. It certainly has, we have a lot of room that we need to cover in terms of making it accessible. There are a lot of logistical difficulties that people face when they have a medical diagnosis that has already pushed them to the limits, and now they have to go through this rigmarole to try and identify doctors that will support them. It can be a very challenging logistically challenging situation, but it is legal in this state. Palliative sedation, which Bree talked about earlier in the day, is generally regarded as a legal option. It's generally regarded as a medical decision between the patient and his or her physician. There have been a number of U.S. Supreme Court cases that have identified or that have supported this concept of palliative sedation, even if it results in the patient becoming unconscious or ultimately in dying or hastening death. VSED is the more difficult inquiry, if you will. And what I like to do is think about it in two separate kind of contexts. If I'm an adult and I am competent to make my medical decisions, I have capacity, legal and medical capacity to make my decisions, and I have some kind of medical reality that to me is unacceptable, then choosing to VSED, choosing to stop eating and drinking is not generally going to be considered that big of a deal. It's not, you're not going to find a statute, a law that says explicitly you have a right to VSED, and similarly you're not going to find a prohibition that says it is illegal to VSED. But what we know is that we all have the right to decline medical treatment, right? So I can complete an advance directive that says if I drop to the floor and I no longer have a pulse or respiration, then I don't want CPR, or I don't want to be put on a vent, or I don't want dialysis if I have kidney malfunction. Whatever it is, we firmly in this country recognize that a competent adult has the right to decline medical treatment. And many scholars on VSED believe firmly that declining food and hydration is simply an extension of that same right. It hasn't been challenged in a legal case yet, so it hasn't percolated up through the state courts to the U.S. Supreme Court, but that's a pretty solid foundation of jurisprudence that says we can decline medical treatment, including food and hydration. The other legal theory that supports this idea that we can choose to stop eating and drinking and that that's a legal option is this idea that we can say what is or is not permissible contact to us. And if I say I do not want food or hydration and someone is force feeding me or putting in a hydration IV against my wishes, then that is criminal battery. And generally speaking, that is also a really well or solidly recognized legal foundation for making one's own decisions, including the decision to stop eating and drinking. The reason that I said that if you're a competent adult making this decision, I don't think that you're going to experience a lot of legal pushback from anyone. I think that you're going to experience a great deal of institutional pushback and logistical pushback. So even though it's a legal decision, we definitely recognize that long-term care institutions are very uncomfortable with this conversation, to the point where if you talk about it openly prior to admission, it's pretty much a sure thing that you won't be admitted. Now it gets a little thornier if you've already been there and now your surrogate is talking about declining hydration or nutrition on your behalf. You're going to get into a lot of really difficult case-by-case scenarios in that situation. One of my practical responses to that is people have been passing away by stopping eating and drinking forever. It's the way that bodies shut down. When you go to an institutional care setting and you see people that are at the very end of life, they are not taking on a lot of hydration and they are not taking in a lot of nutrition. And so then you start, the dialogue starts to be, well, what's going to be our response? Are we going to affirmatively, start force feeding high calorie, smoothie goop to get calories in? Are we going to set IV hydration? Are we going to put in a feeding tube? Are we going to spoon feed? Those are affirmative acts. And so what I would encourage you to do when you're doing your advance directive, which should be updated regularly based on your changing medical reality, is to put explicit notations in it. If you know that you have a diagnosis that will result in a situation where you will not, where your reality will be unacceptable to you, then make it clear what you want, what decisions you want made. So say, I do not authorize or I do not consent to spoon feeding. There's a tragic case north of the border where a woman, even though she had similar type of language in her advance directive, she's been maintained with artificial hydration and nutrition, or spoon feeding, for 17 years. And it's gone through the court cases, and it's a tragic situation because she is gone for all intents and purposes as a result of her dementia diagnosis, but she continues to have a reflex, an automatic reflex. So I have a 3-month-old baby at home, and if you touch his cheek, he will turn towards the stimulus and he will open his mouth. And it's a great reflex when you're trying to, grow an infant. Well, we have that same reflex when we're at the very end of life. And this woman continues, if her cheek is touched with a spoon, she will continue to turn her head and open her mouth. And the courts have construed that in Canada, in this particular jurisdiction, as consent to that nutrition. When the rest of us feel like that's just an automatic reflex that in no way is negating her previous declaration that she didn't want nutrition and hydration when she was at the end stages of this diagnosis. So I encourage you to be very, very specific in your advance directive or in your supplement to your advance directive. Make it very clear what you want and what you don't want. I can't guarantee that it will be honored in every situation, but I can guarantee that if it's there in great detail, then we will have the foundation that we need to advocate for you as vigorously as we can. The more difficult situation, I think, for VSED is a situation where myself as a competent adult has an Alzheimer's diagnosis, and unlike Phyllis's husband, who decided to initiate the VSED process while he still had capacity to do so on his own, I might be a competent adult with a dementia diagnosis who completes an advance directive that says, if at this time in the future, when I no longer have capacity, and when maybe I'm no longer able to mechanically bring food to my mouth on my own, at that point in time, I want to stop eating and drinking. Well, that's a wholly different inquiry, right? I mean, that has a lot of really layered ethical and legal implications that were referenced by a number of the speakers. And I wish I could say that I have a really clear and definitive answer for you, but we just don't yet. What I can tell you is that this conversation is emerging, and we're having a lot of really positive, it's being received really well. End of Life Washington, we're working to clarify, to really think about VSED and think about how we can better advocate for patients that are facing this type of end-of-life choice. So things are changing, things are happening. At the conference that Phyllis mentioned a few weeks ago in Seattle, the first national conference on VSED, we were lucky enough to have 2 members of the Ombudsman's Office for Long-Term Care in Washington State. So it was the Ombudsman and then her attorney. And they were both very, very supportive of this idea that patients have a right to choose to stop eating and drinking. And for those of you who don't know, the Ombudsman's Office is there to advocate for patients' rights. And so they said in no uncertain terms, if you or a loved one is in this situation and you're confronted with some friction from the institutional setting, saying, no, we won't honor this choice, then give them a call and they will advocate for you. Yeah.
What about Phyllis's situation where a social worker comes and says there's been a report? the person is at that more advanced stage of Alzheimer's and can't have the conversation with the social worker, what would you advise is what kind of paperwork would you need to be protected so the social worker wouldn't institute some sort of proceedings
Yeah.
against, or...
I think that brings up two situations. The first is I'm competent when I start the VSED process, but over the course of the first couple of days, I start to go in and out of competency, if you will, just from the natural delirium that sets in from the physical process of dehydration. With anyone who's choosing to VSED, I am a strong believer that you need to plan early and you need to plan well. So I strongly encourage people to have the detailed advance directive, a very clear power of attorney. I also encourage them to have a very clear and witnessed and notarized statement about their direct wish to VSED. And I've also prepared documents that are releases. So if I'm the individual who's choosing to VSED, I have to have a support team. And so I fill out a release and acceptance of liability for that care team. So that when that call comes in, when that social worker arrives to investigate, we can show them this is a well planned out process, this was a deliberate decision that was made, here's all the paperwork. In Phyllis's situation, we were really lucky because Alan was still able to speak with her and to communicate the reason behind his decision. If it had been a few days later in the process, he might have not had that ability to do that. I think that the paperwork would have still supported the same outcome, but we won't really know. Yeah.
So I work for Protective Services, I'm a social worker, 15 years in, and as I was listening to this story, I was like, oh great, yay, she has everything she needs. And then I was waiting, like, when's APS gonna get called just to be that? I mean, what is APS, Adult Protective Services? That it's scary, yes, but bottom line, it is a protection. And everything lined up, all the paperwork, everything lined up. A quick call the social worker could have done to the doctor to say, yes, I know what's happening, and yes, we would go away.
Yep.
And they did.
And they did. And I think, when we see cases that are challenged legally, there's a few cases. There's a case that was recently in Washington, South Sound, I think. There's a case coming up in Oregon. The more difficult cases are where the level of care and attentiveness to the person who's making this decision is not there. So maybe they have bed sores. Maybe they're lying in linens that are not clean. These are not, when you choose to VSED, when you choose to use Death with Dignity, whatever it is you choose to do at the end of your life, you need a support network. You need people to advocate for you and to care for you as you slip away. And you need planning and you need that team. It was very clear to this investigator that this man was surrounded by so much love and that he was supported and that he was making this decision of his own free will. There are a lot of situations, though, where you do have vulnerable adults, and they are in situations that some of us would consider unacceptable. Maybe their decision to stop taking on hydration and nutrition is acceptable, but the other surrounding circumstances can be concerning. So this is a really complex situation.
In a situation where someone is choosing VSED, is it legal for them to get medical care, like pain medication? Or do doctors put themselves in a vulnerable legal situation?
So the question is, when someone chooses VSED, can they get the medical support, medications that they might need for pain management or for other things, and is the physician put at risk?
So physicians and attorneys are all kind of risk-averse people, right? But what I often find when I'm talking with physicians is that they would love it if we just had a green light, if there was some statute in play that said, VSED is legal, there will be no legal repercussions to any physician who assists a patient with VSED. We don't have that yet. So second best scenario is we have a legal case that comes up and it's conclusively said essentially the same thing. Well, we don't have that yet. But like I said, we also don't have any prohibitions against it, and we have really well-established case law saying we can decline treatment, we can say that we don't want certain types of contact, and that type of contact, unwanted contact, is battery. So the simple answer to your question, I think, is that if you have your legal documents in place, my hope would be that they include a release of liability that makes it clear that this physician is treating your symptoms. And those symptoms were discussed earlier, I think, by Terry Law. And they are both physical and they are psychological. There's pain that's involved, so the treatment of pain, the amelioration of extreme thirst, the amelioration of extreme anxiety. And there's medication that can treat those symptoms. And a couple slides ago, I had some Supreme Court cases that talk about palliative sedation. Those same cases talk about physicians having the right to manage their patient's symptoms, even if it results in sedation and/or, leading to unconsciousness and/or hastening of death. So that's kind of the legal body that I would direct a physician to.
Another question for Erin? Yes.
Hi. Back to the paperwork, the advance directive. Oftentimes when I'm out doing a WAHA presentation, oftentimes someone will ask, well, even if I do this and it's notarized and it's signed and it's legal, can a family member or a loved one come in and change it?
Okay, so the question is, if you have a filed advance directive, notarized, legal, put in all the right places, could a family member come in and overturn it?
Yes.
The quick answer that I think is a little bit unsatisfactory is that technically speaking, no. But the reality is that when you have someone that is at the end of life, they're going to be surrounded by a community of people. And it's not uncommon to have one or two of those people possibly disagree with their decisions.
Right.
And whether or not they have the ability to formally change the language, which I don't believe that they do, they certainly could get the ear of the treating physician. They could certainly make things difficult, which is why I encourage people to update their document regularly. So maybe I did a document now and I'm in my 30s, and then I'm in my 50s and I get some kind of crazy medical diagnosis. I update it then, so that there's clear language in there that tells my family members, but also tells my treating medical professionals, I've thought about this type of situation before, and this is the type of care or intervention that I want or don't want. And that's instructive to the physicians, but it's often really instructive to the family members.
And that's one more reason why you have these conversations continually. It's not just one conversation with one person, but if you've appointed a medical power of attorney, you should make it very clear to the rest of your family that you've done so, and your reasoning why you've made the choices that you've made. And you mentioned WAHA, so I just want to, in addition to the Advanced Care Directive that's available End of Life Washington's website, we also have a local agency, the Whatcom Alliance for Health Advancement, that has trained facilitators, which I'm sure you're one of, who will help you fill out that advance directive. If you look at it on your own and you think, I don't know how to make these decisions, they are trained to help guide you through the conversations that will let you explore the values you have and your family has about your own end-of-life choices. So we're not advocating any one choice over another. Instead, we're saying we want you to be well informed. And I want to make one other small pitch to, there's another group in our community who's trying to educate us better on what our end-of-life choices are, and that's Mickey Jackson and two ICU nurses, Koala and Kathy, have been doing presentations around our communities on the realities of advanced medical intervention. So you may not know what it means to have CPR if you're 75. It's a very different thing than if you're 25. You may not know what it means to be on a ventilator and what that choice means. So when you take your loved one to the emergency room and you say, they say, shall we do everything? You of course say yes. You love them. But maybe if you love them, you should say no to some of these things. So I encourage you to, Mickey had a table in there. Hopefully she will be there after the presentation, and she can let you know when the next presentations are. So time for one more question from Erin, then we're going to have a small chance for you to talk to each other, and then we have one last presenter. So is there one more question? Yes.
Yeah, I don't know if this is a question for you, but I think it is. I think that it was Grace said that at the time of her husband's death that it wasn't legal for the hospice nurse to be with
Present.
them, present. And my understanding currently is that it has changed. Some of the nurse can be in the house but not in the room, or something like that, maybe outside and then can come back in, but can you
Yeah.
clarify that, please?
What I have found in my experience, and Bree mentioned this at the end of, or when she was sitting in that chair, she said, but some of us are better at following rules than others. And that's my experience as well. So,
But
so,
legally.
but legally well,
Or not
first let me
legally,
answer
really it's
practically.
policy.
It's not a legal question, it's a policy
Yeah.
question.
So first I'm going to answer with practically what I often find these days is that the hospice nurse will be there providing care, will step out of the room while the patient administers, and then will step back in the room and continue to provide care. I can't say that that happens in every situation, but that is consistently what I'm finding.
Okay,
And if you're doing Death with Dignity through End of Life Washington, then they also have a volunteer that's often there for the duration.
thank you, Erin.